Hello and welcome to Bar 10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. To that end, we've uploaded small groupings of questions, answers, and full analysis. Today we have lesson number 62. Let's get right into it with question number 1. Question number 1. Dooley was a pitcher for the City Robins, a professional baseball team. While Dooley was throwing warm-up pitches on the sidelines during a game, he was continuously heckled by some spectators seated in the stands above the dugout behind a wire mesh fence. On several occasions, Dooley turned and looked directly at the hecklers with a scowl on his face, but the heckling continued. Dooley wound up as though he was preparing to pitch in the direction of his catcher. However, the ball traveled from his hand at a high speed at a 90-degree angle from the line to the pitcher and directly toward the hecklers in the stands. The ball passed through the wire mesh fence and struck Patricia, one of the hecklers. Patricia brought an action for damages against Dooley and the City Robins based upon negligence and battery. The trial court directed a verdict for the defendants on the battery count. The jury found for the defendants on the negligence count because the jury determined that Dooley could not foresee that the ball would pass through the wire mesh fence. Patricia has appealed the judgments on the battery counts, contending that the trial court erred in directing verdicts for Dooley and the City Robins. For this question only, assume that on appeal, the court holds that the question of whether Dooley committed a battery is a jury issue. The judgment entered on the directed verdict in favor of the City Robins should then be A. Reversed and the case remanded because a jury could find the City Robins vicariously liable for a battery committed by Dooley in the course of his employment. B. Reversed and the case remanded only if a jury could find negligence on the part of the Robins management. C. Affirmed because an employer is not vicariously liable for a servant's battery. Or D. Affirmed if Dooley's act was a knowing violation of team rules. Take a few seconds. Choose your best answer now. I hope you chose option number A, reversed and the case remanded because a jury could find the City Robins vicariously liable for a battery committed by Dooley in the course of his employment. Now, let's take a look at why that would be the best answer and why the other three might not. Remember, respondeat superior states that if an employee commits a tort in the scope of their employment, the employer will be vicariously liable. However, an employer is generally not liable for the intentional torts of employees unless the intentional tort involves action specifically authorized by the employer, or is in the nature of the employment, or is motivated by the desire to serve the actual employer. Here, the trial court directed a verdict for the defendants on the battery count. However, based on the facts of the case, a reasonable jury may reach a decision to the contrary. Dooley was scowling at the hecklers prior to throwing the ball 90 degrees at them and hitting Patricia. So a jury could easily conclude that he committed an intentional tort of battery as opposed to an unintentional tort. While an employer is generally not vicariously liable for the intentional torts of their employees, a jury could easily find Dooley was acting in the nature of his pitching duties or was motivated by the desire to serve the City Robins by silencing the hecklers. Thus, a jury could easily find City Robins vicariously liable for the battery committed by Dooley in the course of his employment as a pitcher. Let's look at options B through C and D as well, and why they would not be correct. B, reversed and the case remanded only if a jury could find negligence on the part of the Robins management. If you know anything about baseball, management would be irrelevant to where we would stand as far as vicarious liability and ownership. At the end of the day, the managers are simply employees as well, and they are not necessarily reflective of the ownership. They are, in essence, other players, older players. They are coaches, realistically. So B would not be an appropriate response. C, affirm because an employer is not vicariously liable for a servant's battery. Remember, the employer is not vicariously liable for intentional torts. Now, if it could be seen that this battery was unintentional in any way, shape, or form, then that obviously negates C as a possible option. However, that being said, this would arguably be a jury issue. It would be a jury issue or an issue for the trier of fact to make a decision as to whether there would be any liability. So C would not be the best answer. It's D, affirmed if Dooley's act was a knowing violation of the team rules. That being said, the team rules are not especially relevant here. There probably isn't a rule about attacking players or about missing a pitch or anything of the sort. However, that being said, even if there were a rule specifically against the behavior, arguably the employer could still be held vicariously liable, because what if he instructed the player to act accordingly? What if, again, the player thought it was in the best interest of the employer to behave this way? Or a situation was created where the injury was the result of the negligence of the employer. Any of those scenarios, B through D, would be in essence negated as possible answers to this question pattern. So we're left with A, and only A, as a possible answer. Question number 2. Green contracted in a signed writing to sell Greenacre, a 500-acre tract of farmland, to Farmer. The contract provided for exchange of the deed and purchase price of $500,000 in cash on January 15th. Possession was to be given to Farmer on the same date. On January 15th, Green notified Farmer that because the tenant on Greenacre wrongfully refused to quit the premises until January 30th, Green would be unable to deliver possession of Greenacre until then. But he assured Farmer that he would tender the deed in possession on that date. When Green tendered the deed in possession on January 30th, Farmer refused to accept either and refused to pay the $500,000. Throughout the month of January, the market value of Greenacre was $510,000, and its fair monthly rental value was $5,000. Will Green probably succeed in an action against Farmer for specific performance? Here are your 4 options. A, yes, because the court will excuse the delay in tender on the ground that there was a temporary impossibility caused by the tenant's holding over. B, yes, because time is ordinarily not the essence in a land sale contract. C, no, because Green breached by failing to tender the deed and possession on January 15th. Or D, no, because Green's remedy at law for monetary relief is adequate. Take a few seconds and choose what you believe to be the best answer now. I hope you chose option B. Yes, because time is ordinarily not of the essence in a land sale contract. Remember that a material breach is a refusal to perform under the contract that goes to the heart of the promised performance. Failing to close on a land sale on a specified date does not generally constitute a material breach unless there's specifically a term of time is of the essence within the contract. Instead, both parties to the land sale contract are generally entitled to reasonable reschedulings of the closing date. Specific performance is generally available for contracts involving the sale of real estate. Please remember that. Here, Green wanted to reschedule the closing date from January 15th to January 30th because the tenant wrongfully refused to quit or leave the premises. Green was then likely entitled to such a rescheduling since there is no evidence indicating that the contract contained a time is of the essence clause. Rather than constitute a material breach, this 2-week rescheduling would probably be deemed as reasonable, especially given the fact that the reason for the rescheduling is the fact that the owner, the current landowner, wanted to secure proper title, clean title, in order to make that transfer. Farmer's subsequent refusal, however, to accept Greenacre's deed in possession on January 30th does in fact constitute a material breach. There was no basis for his refusal. This would entitle Green to specific performance. Thus, Green is probably likely to succeed in an action against a farmer for specific performance because time is normally not of the essence in any land sale contract. Let's look at options A, C, and D. Option A, yes, because the court will excuse the delay in tender on the ground that there was a temporary impossibility caused by the tenant's holding over. Well, that's possibly accurate, but that being said, that's not the real reason. The real reason here is that there is no time is of the essence clause. If there was a time is of the essence clause, then A would be out. And B, the reality is that when it comes to land sale contracts, these types of things are pretty common. If any of you have purchased a home or know anyone that has, then the likelihood is that your closing date has been rescheduled multiple times. It's a very common thing. So A would be out. C, no, because Green breached by failing to tender the deed in possession on January 15th. We just went through the analysis, and this is inaccurate because land sale contracts generally are a bit more flexible than others, especially if there is no time is of the essence clause. There's no word in the call of this question that there is such a clause, so we can assume that it may not be there because otherwise it would have been an important fact and it would have been included in the call of this question. So C should be removed as a possible option. And D, finally, no, because Green's remedy at law for monetary relief is adequate. Now, that's inaccurate because at the end of the day, we're looking at the value of rent being $5,000, right? We have that fact thrown in there. Is that, in fact, actually relevant given the fact that we have a 2-week delay here? So arguably, could you say that the defendant's debt or the defendant's liability here is simply the rental value for a set period of time? There's absolutely no discussion in the call of the question. There's no facts. There are no clauses. So the likelihood of the court using a fact like that is, in essence, pulling it out of thin air. And court generally does not like to do that. It does not like to assume facts that are not presented to it, and generally the court also does not make up clauses to contracts that weren't included in the original writing. So D would likely be removed as a possible option, and you'd be left with only B. Yes, because time is ordinarily not of the essence in a land sale contract. Okay, let's move on to question number 3. John Doe, the owner of a milk container manufacturing firm, sought to focus public attention on the milk packaging law of the state of Clinton in order to have it repealed. On a weekday at 12 noon, he delivered an excited, animated, and loud harangue on the steps of the state capitol in front of the main entryway. An audience of 200 onlookers who gathered on the steps heckled him and laughed as he delivered his tirade. Doe repeatedly stated, gesturing expressively and making faces, that the G-damned or milk packaging law is stupid and that I will strangle every one of those damn legislators I can get hold of because this law they created proves they are all too dumb to live. After about 15 minutes, Doe stopped speaking and the amused crowd dispersed. There are 3 relevant statutes of the state of Clinton. The first statute prohibits all speech-making, picketing, and public gatherings of every sort on the Capitol steps in front of the main entryway between 7:45 a.m. and 8:15 a.m., 11:45 a.m. and 12:15 p.m., 12:45 p.m. and 1:15 p.m., and 4:45 p.m. and 5:15 p.m. on Capitol working days. If Doe is prosecuted under the Capitol Step statute and defends on constitutional grounds, which of the following best describes the proper burden of proof? Option A. Doe would have to prove that the state did not have a rational basis for enacting this statute. B. Doe would have to prove that the state did not have a compelling need for this statute or that it had less restrictive means by which it could satisfy that need. Option C. The state would have to prove that it had a rational basis for enacting this statute. Or option D. The state would have to prove that the statute served an important governmental interest and that it was narrowly tailored to satisfy that need. Take a few seconds and choose what you believe to be the best answer now. I hope you chose option letter D. The state would have to prove that the statute served an important governmental interest and it was narrowly tailored to satisfy that need. Remember that in order for content-neutral regulations of protected speech in a public forum to be held constitutional, the regulation has to be viewpoint neutral and subject matter neutral. A time or place manner restriction serves important governmental interests, be narrowly tailored to that governmental interest, and leave open some alternative channels of communication. In this case, John Doe violated a statute prohibiting all speech. Remember that language, all speech. Making, picketing, and public gatherings of every sort, regardless of what the content of the speech is, on the Capitol steps in front of the main entryway between very specific hours on Capitol working days. This is content neutral, time, manner, or place restriction on protected speech. So the burden of proof would be on the state to prove that the statute served an important governmental interest and that it was narrowly tailored to satisfy that need. So D would be the only option. If we look at options A and B, first, they look at the very incorrect standard or the burden of proof, but more importantly, they also place the onus on Doe, which is the filing party. At the end of the day, it would be very impossible, if not at least very difficult, for Doe to prove that there is or is not a rational basis for a particular piece of legislation filed by or created by a state. Generally, the burden will shift, and the defendant will have to show the rational basis, the intermediate scrutiny, or that strict scrutiny is met. So as a result, A and B should generally be eliminated right off the bat. C, the state would have to prove that it had a rational basis for enacting this statute. Again, we're looking at fully content-neutral regulation. So that being said, the standard is not rational basis, but one of an important governmental interest. So as a result, only option D would be correct here. Okay, let's move on to question number 4. On December 1st, broker contracted with Collecta to sell her one of a certain type of rare coin for $12,000. Delivery and payment to occur on the next March 1st. To fulfill the contract, and without Collecta's knowledge, broker contracted on January 1st to purchase for $10,000 a specimen of that type of coin from Hoarder. Delivery and payment to occur on February 1st. The market price of such coins had unexpectedly fallen to $8,000 by February 1st, when Hoarder tendered the coin and broker repudiated. On February 25th, the market in such coins suddenly reversed and had stabilized at $12,000 on March 1st. Broker, however, had failed to obtain a specimen of the coin and repudiated his agreement with Collecta when she tendered the $12,000 agreed upon price on March 1st. Later that day, after learning by chance of brokers dealing with Collecta, Hoarder telephoned Collecta and said, "Listen, broker probably owes me at least $2,000 in damages for refusing wrongfully to buy my coin for $10,000 on February 1st, when the market was down to $8,000. But I'm in good shape in view of the market's recovery since then, and I think you ought to get after the so-and-so." If Collecta immediately sues broker for his breach of the broker-hoarder contract, which of the following will the court probably decide? A, broker wins because Collecta, if a beneficiary at all of the broker-hoarder contract, was only an incidental beneficiary. B, broker wins because as of March 1st, neither Hoarder nor Collecta had sustained any damage from broker's repudiation of both contracts. C, Collecta wins because she was an intended beneficiary of the broker-hoarder contract, under which damages for broker's repudiation became fixed on February 1st. Or D, Collecta wins because she took an effective assignment of Hoarder's claim for damages against broker when Hoarder suggested that Collecta get after the so-and-so. Take a few seconds and choose what you believe to be the best response now. If you chose option A, broker wins because collector, if a beneficiary at all, of the broker-hoarder contract was only an incidental beneficiary. You'd be correct, and good job. This was a slightly convoluted question. A third-party beneficiary may exist when two parties make a contract with a shared intent to benefit a third party. An intended third-party beneficiary has contract rights just as the parties to that contract do, and will always be named in the contract on the bar exam. However, an incidental third-party beneficiary does not have contract rights and will not be named in the contract on the bar exam. So please note that very strong distinction. Here, collector could assert the right to sue broker for his breach of the broker-hoarder contract if she was a third-party beneficiary. However, collector was not named as a beneficiary in the broker-hoarder contract. Even if collector were to be considered an incidental beneficiary of that contract, incidental beneficiaries do not have contract rights, so she would not have had the right to sue under that contract. Accordingly, the court will probably decide that broker wins because collector, if a beneficiary at all of the broker-hoarder contract, was only an incidental beneficiary. Let's look at options B through C. Let's go in the inverted order. D. Collector wins because she took an effective assignment of hoarder's claim for damages against broker when hoarder suggested that collector get after the so-and-so. Honestly, I don't know what that language means. I would immediately eliminate D as an option simply because it makes no logical, grammatical, or any sense whatsoever as a possible option. So let's look at C now. Collector wins because she was an intended beneficiary of the broker-hoarder contract under which damages for broker's repudiation became fixed on February 1st. Well, the question is here, was she in fact an intended beneficiary? Now, that being said, there may have been some intent on one of the parties for there to have been some sort of benefit because there'd be a resale in essence. But that being said, she was not actually in fact named as a party nor named as a beneficiary. So a one-sided potential beneficiary does not fall into an intended beneficiary of the contract. It has to be intended by both parties of that contract. B. Broker wins because as of March 1st, neither hoarder nor collector had sustained any damage from broker's repudiation of both contracts. Well, that's actually in fact untrue because the person who intended to purchase the item was not able to purchase the item. That in and of itself is deemed a damage or deemed a harm. She is, or that purchaser is, without the product that they intend to purchase and that they had contracted to purchase for. So that being said, B would be inaccurate and A would be the only possible response here. We're almost to the halfway mark. Here's question number 5. Ann's 3-year-old daughter, Janet, was killed in an automobile accident. At Ann's direction, Janet's body was taken to a mausoleum for interment. Normally, the mausoleum's vaults are permanently sealed with marble plates secured by tamper-proof screws. After Janet's body was placed in the mausoleum, however, only a fiberglass panel secured by caulking compound covered her vault. About a month later, Janet's body was discovered in a cemetery located near the mausoleum. It had apparently been left there by vandals who had taken it from the mausoleum. As a result of this experience, Anne suffered great emotional distress. If Anne sues the mausoleum for the damages arising from her emotional distress, will she prevail? A. No, because Anne experienced no threat to her own safety. B. No, unless the mausoleum's behavior was extreme and outrageous. C. Yes, if the mausoleum failed to use reasonable care to safeguard the body. Or D. Yes, unless Anne suffered no physical harm as a consequence of her emotional distress. Take a few seconds and choose what you believe to be the very best answer here now. The correct answer here would be option C. Yes, if the mausoleum failed to use reasonable care to safeguard the body. Remember that in order to establish prima facie negligence, you must prove a duty, a breach of that duty, causation, and actual damages. Normally, the negligent infliction of emotional distress requires a plaintiff to show physical consequences resulting from emotional distress in order to prevail under a theory of negligent infliction of emotional distress. However, physical consequences are not required for egregious conduct, such as an erroneous report of a relative's death or the mishandling of a relative's corpse. In this case, the mausoleum had a special relationship with Anne because the mausoleum served as an interment site for Anne's daughter, Janet. The mausoleum's vaults were normally permanently sealed with marble plates, secured by tamper-proof screws. However, Janet's vault was secured only by a fiberglass plate secured by caulking compound. The mausoleum was likely negligent by failing to use the proper standard that it itself has implemented with every other interment. Janet's body and its breach allowed vandals to mishandle Janet's corpse. Therefore, Anne will prevail in her suit if the mausoleum failed to use reasonable care to safeguard her daughter's body. Let's look at option A. No, because Anne experienced no threat to her own safety. Remember that under these types of situations where someone's handling a corpse or a body or an interment, something to the sort, the standard's a bit different. There is no direct physical threat that's required here. B. No, unless the mausoleum's behavior was extreme and outrageous. This is an inversion of the standard. Ultimately, there doesn't have to be extreme or outrageous behavior. It just has to be a failure to meet the reasonable standard. So A and B should be eliminated right off the bat. D, yes, unless Anne suffered no physical harm as a consequence of her emotional distress. D seems to be a bit illogical at first, and that's because it in fact is. Yes, unless Anne suffered no physical harm as a consequence of her emotional distress. So it's basically, will she prevail? Yes, especially if she wasn't physically hurt. That doesn't make very much sense. So A, B, and D should be eliminated, and option C would be your only correct answer here. Good job, you've gotten through that halfway point. Question number 6. For an agreed price of $20 million, Buildco Incorp. contracted with Venture to design and build on Venture's commercial plot a 15-story office building. In excavating for the foundation and underground utilities, Buildco encountered a massive layer of granite at a depth of 15 feet. By reasonable safety criteria, the building's foundation required a minimum excavation of 25 feet. When the contract was made, neither Venture nor Buildco was aware of the subsurface granite, for the presence of which neither party had hired a qualified expert to test. Claiming accurately that removal of enough granite to permit the construction as planned would cost them an additional $3 million and a probable net loss on the contract of $2 million, Buildco refused to proceed with the work unless Venture would promise to pay an additional $2.5 million for the completed building. If Venture refuses and sues Buildco for breach of contract, which of the following will the court probably decide? A. Buildco is excused under the modern doctrine of supervening impossibility, which includes severe impracticability. B. Buildco is excused because the contract is voidable on account of the parties' mutual mistake concerning an essential underlying fact. C. Venture prevails because Buildco assumed the risk of encountering subsurface granite that was unknown to Venture. Or D. Venture prevails unless subsurface granite was previously unknown anywhere in the vicinity of Venture's construction site. Take a few seconds and choose what you believe to be the very best response here now. The best answer here is option C. Venture prevails because Buildco assumed the risk of encountering subsurface granite that was unknown to Venture. Generally, a party to a contract that assumes a risk of something occurring can't later have its performance excused based on that event actually in fact occurring. Here, Buildco contracted with Venture to design and build on Venture's commercial plot a 15-story office building. Neither party was aware of the subsurface granite below the plot, although a qualified expert could have tested for it. but not testing for subsurface granite, Bilco assumed the risk of the subsurface granite being present. Bilco cannot now have its performance excused due to the presence of the subsurface granite, since Bilco assumed the risk that it would be present. As such, the court will probably decide that Venture prevails because Bilco assumed the risk of encountering subsurface granite that was unknown to Venture. Now, if you look at option A, Bilco is excused under the modern doctrine of supervening impossibility, which includes severe impracticability. Now, simply because something becomes impracticable or impossible doesn't necessarily negate a contract, doesn't necessarily void a contract. The issue here is that the onus fell upon the purchaser to test for it, or the builder to test for these items before going into a contract. If they chose not to, then in essence, they're taking on that responsibility. So A would be inaccurate. B, Bilco is excused because the contract is voidable on account of the parties' mutual mistake concerning an essential underlying fact. We just did the analysis as to A, and why A is incorrect. It would be the same logic as to why B would be incorrect. There is no mutual mistake. The one party did not need to know about the information, while the party who's actually in fact doing the building should have properly tested for it. There was no need for the landowner to test for it or to look for it. The only way that this would have been an issue for liability is if in fact the landowner knew about the granite and simply didn't mention it. D, Venture prevails unless subsurface granite was previously unknown anywhere in the vicinity of Venture's construction site. Not relevant, simply because the building company did not test for it, and they should have. They were the ones building. They began digging prior to doing any appropriate testing. As a result, they assumed the liability, or they assumed the issue if one would arise. And guess what? It did. Question number 7. Blackacre is a 3-acre tract of land with a small residence. Olga, the owner of Blackacre, rented it to Terrence at a monthly rental of $200. After Terrence had been in possession of Blackacre for several years, Terrence and Olga orally agreed that Terrence would purchase Blackacre from Olga for the sum of $24,000, payable at the rate of $200 a month for 10 years, and also would pay the real estate taxes and the expenses of insuring and maintaining Blackacre. Olga agreed to give Terrence a deed to Blackacre after 5 years had passed, and $12,000 had been paid on account, and to accept from Terrence a note secured by a mortgage for the balance. Terrence continued in possession of Blackacre and performed his obligation as orally agreed. Terrence, without consulting Olga, made improvements for which he paid $1,000. When Terrence had paid $12,000, he tendered a proper note and mortgage to Olga and demanded delivery of the deed as agreed. Olga did not deny the oral agreement, but told Terrence that she has changed her mind, and she refused to complete the transaction. Terrence then brought an action for specific performance. Olga pleaded the statute of frauds as her defense. If Olga wins, it'll be because A, nothing Terrence could have done would have overcome the original absence of a written agreement. B, the actions and payments of Terrence are as consistent with his being a tenant as with an oral contract. C, Terrence did not secure Olga's approval for the improvements that he made. Or D, Olga has not received any unconscionable benefit, and therefore Terrence is not entitled to equitable relief. Take a few seconds and choose what you believe to be the best answer here now. The very best answer here is option B. The actions and payments of Terrence are as consistent with his being a tenant as with the oral contract. The statute of frauds requires certain contracts to be in writing in order for them to be enforceable. Contracts incapable of being performed within 1 year, sale of goods over $500, promises made in consideration of marriage, guarantee to pay the debt of another, executor promises to pay its state debts with their own funds, and transfers of interest in real estate. One exception of the statute of frauds is a lease of 1 year or less. While writing is generally required for a land sale contract, the statute of frauds can be satisfied by part performance by the owner. Part performance requires 2 out of 3 of the following: the buyer, in fact, taking possession, the buyer pays all or part of the purchase price, and the buyer makes substantial improvements to the land. Terrence's agreement with Olga should have been in writing because it involved the transfer of an interest in real estate. The good news for Terrence is that his subsequent actions seem to have satisfied the statute of frauds by part performance because Terrence took possession and paid part of the purchase price. The bad news for Terrence is that Olga can contest this because without a written contract, Terrence's actions also look like he still had a month-to-month tenancy, and he was in fact paying the same exact amount that he was before. As such, if Olga wins, it'll be because the actions and payments of Terrence are as consistent with his being a tenant as with the oral contract for the purchase. Let's look at options A, C, and D and see why they would be incorrect. A, nothing Terrence could have done would have overcome the original absence of a written agreement. We know that's inaccurate. If he meets 2 of the 3 requirements, then it would have been sufficient and he could have gone forward without an actual writing. Option C, Terrence did not secure Olga's approval for the improvement that he made. Irrelevant. D, Olga has not received any unconscionable benefit and therefore Terrence is not entitled to equitable relief. Well, Olga did not receive an unconscionable benefit. She continued to receive the same rent that she previously was receiving from Terrence, and therefore Terrence is not entitled to equitable relief. Now, the lack of receipt of an unconscionable benefit does not necessarily remove the possibility for equitable relief. Here, under this scenario, at the end of the day, well, she did not receive an unconscionable benefit, but she also retained the property, which at the end of the day is a benefit. It's a significant benefit. If the belief is that after 10 years of these payments, you would own the property, and after 10 years of these payments, you now do not own the property, that's a significant benefit. It's a significant loss to the individual making the payments. Where we get into a bit of trouble here is that the rent was the exact same price as those payments would have been. So again, without the contract and without any change in circumstances so that Terrence continues to pay the same exact amount, there can be no real actual supportive evidence of the contract which is alleged here based on these facts. So if in fact it's deemed that there was no contract, then it would be as a result of B. The actions and payments of Terrence are as consistent with his being a tenant as with an oral contract for the purchase of the property. Question number 8. Prad entered drugstore to make some purchases. As he was searching the aisles for various items, he noticed a display card containing automatic pencils. The display card was on a high shelf behind a cashier's counter. Prad saw a sign on the counter that read, "No admittance, employees only." Seeing no clerks in the vicinity to help him, Prad went behind the counter to get a pencil. A clerk then appeared behind the counter and asked whether she could help him. He said he just wanted a pencil and that he could reach the display card himself. The clerk said nothing further. While reaching for the display card, Prad stepped sideways into an open shaft and fell to the basement, 10 feet below. The clerk knew of the presence of the open shaft, but assumed incorrectly that Prad had noticed it. Prad sued drugstore to recover damages for the injuries he sustained in the fall. The jurisdiction has adopted a rule of pure comparative negligence, and it follows traditional common law rules governing the duties of a land possessor. Will Prad recover a judgment against drugstore? Let's look at our options. A, no, because Prad was a trespasser. B, no, unless Prad's injuries resulted from the defendant's willful or wanton misconduct. C, yes, because the premises were defective with no respect to a public invitee. Or D, yes, if the clerk had reason to believe that Prad was unaware of the open shaft. Take a few seconds and choose the best answer now. I hope you chose option letter D. Yes, the clerk had reason to believe that Pratt was unaware of the open shaft. If a duty is owed to those on the premises, the owner can satisfy the duty of reasonable care by either making the condition safe or issuing a warning of the dangerous condition. An invitee is either a person invited onto the land to conduct business with the owner or a person invited as a member of the public for purposes which the land is held open to the public for. A landowner has a duty to warn invitees about known concealed dangers on the land. A landowner also has a duty to warn discovered trespassers about known concealed dangers on the land. Here, Pratt started out as an invitee to the drugstore. He was shopping. When Pratt went behind the counter, despite the sign that read "No admittance, employees only," Pratt may have actually now become a trespasser. When the clerk saw Pratt behind the counter, at which point Pratt may have been a discovered trespasser, the clerk did not object to his presence and didn't ask him to leave. So the clerk may have consented to the trespass. Regardless of his status as an invitee or a discovered trespasser, clerk knew of the dangerous open shaft, so the clerk had a duty to warn Pratt about it. If she had reason to believe Pratt did not know about the shaft, the clerk would have breached their duty owed to Pratt by not warning him of the hidden danger. Accordingly, Pratt can recover a judgment against drugstore if the clerk had reason to believe that Pratt was unaware of the open shaft. Let's look at the other options. A, no, because Pratt was a trespasser. Was he really a trespasser? Was he permitted once the clerk saw him and then continued to speak with him and then allowed him to continue to search for the item that he was looking for? Arguably not. So A could be eliminated. B, no, unless Pratt's injuries resulted from the defendant's willful or wanton misconduct. B, willful and wanton misconduct are not the standard. Remember, you have a duty as a landowner to warn of known dangers. So B would be inaccurate and should be eliminated right off the bat as well. C, yes, because the premises were defective with respect to a public invitee. Well, they were in fact not. The area of defect was outside of the public invitee realm. It was outside of the scope of the area of the store where a public invitee would enter. So that being said, C would be eliminated as a possible option, and we're only left with D as the correct and only possible option here. Question 9, we can see the finish line from right here. Marolf, a wallpaper hanger, sent Jenny Bell, a general contractor, this telegram: "We'll do all paper hanging on new doctor's building per owner specs for $14,000 if you accept within reasonable time after main contract awarded. Signed, Mural." 3 other competing hangers sent Jenny Bell similar bids in the respective amounts of $18,000, $19,000, and $20,000. Jenny Bell used Mural's $14,000 figure in submitting her own sealed bid on doctor's building. Before the bids were opened, Mural truthfully advised Jenny Bell that the former's telegraphic subbid had been based on a $4,000 computational error and was therefore revoked. Shortly thereafter, Jenny Bell was awarded the doctor's building construction contract and subsequently contracted with another paper hanger for a price of $18,000. Jenny Bell now sues Mural to recover $4,000. Which of the following, if proved, would most strengthen Jenny Bell's prospect for recovery? A, after Mural's notice of revocation, Jenny Bell made a reasonable effort to subcontract with another paper hanger at the lowest possible price. B, Jenny Bell had been required by the owner to submit a bid bond and could not have withdrawn or amended her bid on the main contract without forfeiting that bid bond. C, Mural was negligent in erroneously calculating the amount of his subbid. Or D, Jenny Bell dealt with all of her subcontractors in good faith and without seeking to renegotiate or lower the prices they had bid. Take a few seconds and choose what you believe to be the correct answer now. I hope you got this one right. It's option B. Jenny Bell had been required by the owner to submit a bid bond and could not have withdrawn or amended her bid on the main contract without forfeiting that bond. Remember that the rule is that a non-breaching party must take reasonable steps to mitigate damages caused by a breach of a contract. In this case, Murrell advised Jenny Bell that the sub-bid submitted had been based on a $4,000 computational error and was thereby revoked. Jenny Bell, as the non-breaching party, now had a duty to mitigate her damages as best as she could. Since Jenny Bell was given notice of Murrell's revocation prior to the opening of the bids, it's possible that she could have mitigated her damages by simply withdrawing the bid she had submitted on the doctor's building after receiving the notice of Murrell's revocation. Therefore, Jenny Bell's prospects for recovery would be most strengthened if Jenny Bell had been required by the owner to submit a bid bond and could not have withdrawn or amended her bid on the main contract without forfeiting that bond. Now let's look at the three other options and discuss why they would be inaccurate. Option A, after Murrell's notice of revocation, Jenny Bell made a reasonable effort to subcontract with another paper hanger at the lowest possible price. This is not the best answer, and while this is a great effort, it's not the best answer because she simply could have revoked or removed her bid. That would obviously have removed any possible damages on the part of the outside party of Murrell. Now, C, Murrell was negligent in erroneously calculating the amount of his sub-bid. Again, yes, maybe true, but the best way to have protected against it is to have revoked the bid submitted for the job. Then, as a result, Jenny Bell would have had no damages whatsoever, other than the loss of profits of having not done the project. D, but again, let's go back there. But again, she's not guaranteed that she'd even get the project. So that being said, was there in fact a harm? It could be a bit too tenuous at best. D, Jenny Bell dealt with all her subcontractors in good faith and without seeking to renegotiate the prices they had bid. That's a great thing. She's a wonderful person, but again, not especially relevant to this fact pattern. So A, C, and D should be eliminated, and you're left with only B as the possible and correct option. Question number 10, the last question in this grouping. The Federal Automobile Safety Act establishes certain safety and performance standards for all automobiles manufactured in the United States. The Act creates a 5-member automobile commission to investigate automobile safety, to make recommendations to Congress for new laws, to make further rules establishing safety and performance standards, and to prosecute violations of the Act. The chairman is appointed by the president. 2 members are selected by the president pro tempore of the Senate and 2 of the speakers of the House of Representatives. Minicar Incorporated, a minor United States car manufacturer, seeks to enjoin enforcement of the commission's rules. The best argument that Minicar can make is that A, legislative power may not be delegated by Congress to an agency in the absence of clear guidelines. B, the commerce power does not extend to the manufacture of automobiles not used in the interstate commerce. C, Minicar is denied due process of law because it is not represented on the commission. D, the commission lacks authority to enforce its standards because not all of its members were appointed by the president. Take a few seconds and choose the best answer now. I hope we're ending on a high note and that you chose option D. The commission lacks authority to enforce its standards because not all of its members were appointed by the president. Remember that Article 2 vests the executive power in the president and states that the president shall take care that the laws be faithfully executed. The power to enforce laws lies solely within the executive branch. Here, the Act creates a 5-member automobile commission with several functions, one of which is to prosecute violations of the Act. However, only one of the commission's members was appointed by the president. The power to enforce laws lies solely within the executive branch. So the Automobile Commission's power to prosecute violations of the Act would only be constitutional if the president had in fact appointed all of its members. Therefore, the best argument Minicar can make is that the Commission lacks authority to enforce its standards because not all of its members were appointed by the President. Let's take a look at the three other options and present why they would be inaccurate as responses. A. Legislative power may not be delegated by Congress to an agency in the absence of clear guidelines. As we discussed, the key issue here is the appointment by the presidency, and D is the only option that addresses that. A. Legislative power may not be delegated by Congress to an agency in the absence of clear guidelines. That may be accurate, but we're not necessarily relevant here as to this particular fact pattern. B, the commerce power does not extend to the manufacture of automobiles not used in interstate commerce. That may be accurate, but then you'd have to show that none of the automobiles are used in interstate commerce, and that'd be a hard sell. C, Minicar is denied due process of law because it's not represented on the Commission. You don't have to be. Not every sector of society is necessarily represented by the presidency or by an agency. So A, B, and C are not relevant, not necessarily the best options, and D would without question be the best answer here. As always, thank you for joining us on Bar 10, where it's our goal to help you prepare for the bar exam 10 questions at a time. To that end, we've uploaded this video and many, many more just like it. Please take a look at our playlist if you wish to look at more MBE type questions. We'll link it down below.